Good afternoon, all. My name is Dasha Figueroa, a Conflict Resolution Alliance member on the Programs and Events Committee. Thank you for joining us today. Welcome to our Encore presentation and live Q&A on Indigenous Conflict Resolution Practice and Integration. This event is brought to you by the Conflict Resolution Alliance, a local nonprofit that develops and supports peace builders in Hawaii. Thank you to our co-sponsors at the Hawaii State Bar Association, Alternative Dispute Resolution Section, Ku'ikahi Mediation Center, Matsunaga Institute for Peace, Maui Mediation Services, the Mediation Center of the Pacific, and West Hawaii Mediation Center. Also, a special thank you to the Hawaii State Judiciary Center for Alternative Dispute Resolution, the King Kamehameha V Judiciary History Center, Native Hawaiian Bar Association, and the Olelo Community Media. Today's event will be about how Indigenous conflict resolution practices, including Ho'oponopono and Native peacemaking, have been used by both the Native Hawaiian and Native American groups to address conflict in families and the greater community. A distinguished panel of legal academics, practitioners, and peacemakers will probe the possibilities and implications of integrating Indigenous conflict resolution practices in the practice of law and the court system. We have an amazing group of people joining us for today's dialogue. Our mediator is Laurie Tochiki, who is the president and CEO of Epic Ohana, a nonprofit organization serving families in the child welfare system and vulnerable transitional youth. It is also a lecturer at William S. Richardson School of Law in the evening program teaching children and the law and family law. Our panelists today consist of Malia Akutagawa, who is an assistant professor of law at the Hawaiian Studies with both the University of Hawaii at Manoa, Hawaii Inuikai School of Hawaiian Knowledge, Kamaka Ko'okalani Center of Hawaiian Studies, and William S. Richardson School of Law. Also joining us is Euclid Aluli, who is a founding director, president, and current officer of the Native Hawaiian Bar Association. Ms. Aluli is a Native Hawaiian attorney and activist that has a decade-long involvement in Hawaiian affairs. Additionally joining us is Leilani Teal, who is a Kanaka Maoli cultural practitioner and activist. She is currently the Haku Ho'oponopono and project coordinator at the Ho'oponopono Peace Project, a culture-based conflict resolution resource for families, communities, grassroots organizations, and youth. Our last panelist joining us is Sean Watts, who is an associate clinical professor, mediation clinic director, tribal judiciary support clinic director, and the Tribal Law and Government Center director at the University of Kansas School of Law. He formerly served as a lecturer in the law and associate director at the mediation clinic at Columbia Law School. Thank you again for joining us, and now we will turn it over to our event. Thank you.
Aloha, once again. My name is Ann Smoke. I'm with the Judiciary Center for Alternative Dispute Resolution. And before we get started with today's program, I just want to go over a few housekeeping items. First, please note that Olelo is filming. So out of respect to our panelists and our moderator, and in the case that, that they will catch your phone ringing, please silence any personal devices right now. Thank you. Also, you're going to find index cards at your seat. I have my props up here. They look like this. Because Olelo is filming, we want to capture the questions. Cecilia Chang will be reading the questions that come in. So we're going to ask you to write the questions on the index cards. And if our ushers will raise their hands, we have some terrific students from the Columbia School of Law and from the Spark Matsunaga Institute for Peace. They will be your ushers and they'll be walking up and down the aisle. So just hold your card up so we can see it and we'll make sure it gets into the right hands. We're planning to be here until 4:15 today and we don't have any scheduled breaks. However, if you need a stretch break or if you have to take care of business, please step out the back door. Jacqueline, can you raise your hand? Step out that back door there, and you can go around. You can sit down in the lounge, have refreshment if you'd like. There are restrooms on the upper level at the top of the stairs and below the staircase. We appreciate feedback. You're going to also find green forms at your seat. Those are evaluation forms. Please take time to fill that out before you leave. We would love to hear from you and any suggestions or feedback that you have. There are feedback boxes. The evaluation boxes are going to be in the foyer as you exit, or in the small registration table that you might have seen when you came in. So please leave your forms with us, your evaluations. Last of all, if you're requesting CLE credits, please make sure that you've signed in. And on your way out, sign out at the same station, because that's where you'll find your name. It'll be expedient that way. And if everything goes as planned, we'll hand you a CLE certificate on your way out the door. So with those important details taken care of, I'd like to turn over the podium to Cecilia Chang, the director for the Center for Alternative Dispute Resolution, and she'll start our program. Thank you.
Good afternoon, everyone. Thank you for joining us today. And thank you to the Circuit Court of the Second Circuit, Maui, who is joining us by webcast. Last fall, an ambitious third-year law student from Columbia Law School's mediation clinic came home for the holidays. During her vacation break, she reached out to the Hawaii Alternative Dispute Resolution, or ADR, organizations to develop a learning partnership. Cindy Lee explained that Columbia Law School's mediation clinic equips students with problem-solving and conflict resolution skills applicable both within the legal profession and beyond, and that the clinic explores ADR best practices and when ADR is an appropriate alternative to formal legal adjudication. Cindy invited us to partner with prominent ADR scholars from Columbia Law School on an educational forum. That exciting initial discussion grew into a two-day educational exchange, starting with this panel discussion, a talk story later this evening on best practices, and a talk tomorrow at UH on multilateral negotiation, tools for conflict resolution and prevention. This evening's talk story is full, but there are seats available for tomorrow's talk at UH. Kindly grab a flyer on your way out. It's just outside the door. We thank our co-sponsors, whose leaders are right here in the front row. Columbia Law School, well, Cindy Lee and the other students back there, and of course, Professor Sean Watts, and Professor Alex Carter. We thank the Hawaii State Bar Association Alternative Dispute Resolution Section co-chairs Lisa Jacobs, Dick Mosier, and Gary Grimmer. The Native Hawaiian Bar Association, Ho'oponopono, right there in the front. Beatty Dawson, Euclid Aluli, Summer Silva, Sissy Farm, and Dexter Kayama. The Association for Conflict Resolution Hawaii, Amrita Malik, Lisa Nakao. The Mediation Center of the Pacific, Tracy Wilkin, up here in the front. And the Spark Matsunaga Institute for Peace and Conflict Resolution, Maya Soetoro Ng and Jose Barzola. Thank you all for your dedication and energy in promoting ADR. Thank you also to my team, Anne, Becky, David, and Memory, and the many volunteers, including judiciary staff, students from Columbia Law School, and the Spark Matsunaga Institute for Peace and Conflict Resolution. Let me now have the pleasure of introducing our distinguished guest speakers. I'd like to begin with Malia Akutagawa, Assistant Professor of Law and Professor of Hawaiian Studies at the University of Hawaii at Manoa. She will speak from experience as a former litigator turned advocate for proactively engaging people in traditional practices to mitigate problems that end up in court. I'd also like to introduce Euclid Aluli. Euclid will provide invaluable insight as a Native Hawaiian attorney and activist who defends Hawaiian rights within the legal system. It's my pleasure to introduce Professor Sean Watts. Professor Watts, Sean, is a citizen of the Cherokee Nation of Omaha. He's a lecturer in law and associate director of the Columbia Law School Mediation Clinic. Professor Watts specializes in mediation and Native American peacemaking and will discuss Native American models and practices. I'd like to introduce Laulani Teal. Laulani has a wealth of experience in cultural-based conflict resolution in Hawaii. She will speak through her lens, having worked in Ho'oponopono extensively and having guided parties to resolution in disputes relating to Native Hawaiian rights. For more information about our esteemed panelists, please see their detailed biographies in the program. Our moderator today is the president and CEO of EPIC Ohana, a nonprofit organization serving families in the child welfare system and vulnerable transitioning youth. Many of you know her from her 12 years as the Associate Dean for Student Services at the William S. Richardson School of Law. Or perhaps you know her as your professor from the Family Law Clinic. Or you might have known her because she coordinated and co-founded the Kids First program at the Family Court of the First Circuit, as well as the Ohana conferencing program of the Department of Human Services and the Family Court. She practiced family law for over a decade, mostly as a solo practitioner in Waipahu. Her awards are many. I've just abbreviated 4 pages of awards into number 1, now she's getting embarrassed, the Hawaii State Bar Association's Golden Gavel Award, the Volunteer Legal Services of Hawaii NEW Award, the Hawaii Women Lawyers Distinguished Service Award, the Hawaii Women Lawyers Foundation Rhoda Lewis Community Service Award, and the William S. Richardson School of Law Alumni Association Service Award. It's my pleasure to introduce our moderator, Laurie Tochiki. Before we begin, however, I now have the privilege of introducing our Chief Justice of the Hawaii Supreme Court, who will give some context to our discussion today, the Honorable Mark E. Rechtenwald. CJ.
Good afternoon. Aloha, everyone. Welcome to Ali'iolani Hale, the home of the Hawaii Supreme Court. We're honored to have you in our courtroom here today, and thank you for taking time out of your busy schedules to be here for this very important discussion. Almost a year ago, I had the privilege of introducing a living treasure, Bidi Kanahele Dawson, who graciously shared her views on expanding access to justice through Ho'oponopono. Today, we turn our exploration more specifically toward the intersection of Western law and Native Hawaiian cultural practices to better understand the potential of integrating cultural conflict resolution practices into the practice of law and into our Western judicial system. On behalf of the judiciary, I want to extend our appreciation to everyone who's made this event possible. All of the co-sponsors, our Center for Alternative Dispute Resolution, headed by Cecilia Chang and Anne-Marie Smoke. They do a wonderful job. I'm so grateful to them for their hard work. And our distinguished panelists and moderator, thank you so much for being here today. And I'd like to welcome our many distinguished guests, including cultural practitioners in Kumu, Lynette Paglinawan, who's here today in the front row, Auntie Lynette, Roslyn McCullough, and Wade Lee. And I also would like to welcome several members of our legislature, including House Speaker Scott Saiki and Representative Matt Lopresti, and acknowledge the Office of Hawaiian Affairs CEO, Dr. Kamana'o Crabb, who's leading a task force on incorporating principles of Ho'oponopono into our public safety system. We have many attorneys here today, including a number who've traveled from the neighbor islands, and I'd like to extend my deepest thanks to all of them who helped us address the immense community need to increase access to our civil justice system. And I'd like to acknowledge our guests from Columbia Law School. Thank you very much, Professor Watts, for being here today. We have 4 students, and we're very grateful that they made the trip here to Hawaii to share their knowledge with us and also to learn with us and be part of this dialogue with us. I want to thank you all for being here today. We have people from many different backgrounds and diverse views that will contribute to the discussion. And it's my hope that today's panel discussion will start a broader community conversation on where do we go from here. How can we bring Indigenous conflict resolution practices like Native peacemaking and Ho'oponopono into the practice of law? How can Indigenous conflict resolution practices help resolve problems by providing another alternative to litigation? How can the judicial system adapt to accommodate Indigenous Conflict Resolution practices. Through thoughtful debate and open community dialogue, practical solutions will emerge and systemic improvement will follow, expanding access to justice for all. So once again, thank you all for being here today to participate in this important conversation. Good afternoon and aloha.
Thank you, CJ Rechtenwald. I now have the privilege of calling Laurie Tochiki, who will share some of her thoughts and guide today's panel discussion.
Here with this ear thingy, but if it doesn't work, then I'll stand up. So thank you so much. This is such an important conversation, and I'm so pleased that the judiciary and Cecilia, Justice Rechtenwald, that you've opened up this space for what is such a timely and important place for us. So the intersection between the legal process and traditional process, maybe we're not talking just about, can everybody hear me? Yes. Is this thing, okay. So it isn't just a question of which problems go where, but maybe it's also the question of how can the goals of justice and healing be best served at that intersection between the law and the cultural practices. And that's what we're going to examine today. So restorative practices, therapeutic, however you want to discuss it or name it, we're talking about places where consensus and collaboration is more important than a single decision. We're talking about reconciliation and healing. We're talking about purpose, maybe not so much to blame or find fault, but to find out why and the wider reason for the wrong. We're looking at concerns where there's a breach of the law, but more concern for the restoration of community and relationships. So these are all really, really important places where the law and the cultural practices look at these situations and approach them maybe a little bit differently. So how do we work them together? So in this process, we are looking at some of the ethical and procedural places where the two systems come together. So for instance, in our rules or guidelines about civility, about how we approach our work, we talk about the importance of seeking alternative methods of resolution. We look at Rule 11, which says it's our duty as attorneys to find ways to find that healing, to find that some of that restoration, to find settlement outside of the judicial process. It's our responsibility. And also, when we look at the guidelines for Hawaii mediation, although Ho'oponopono, for instance, is specifically excluded from the guidelines about mediation, nevertheless, some of those same issues about confidentiality, about self-determination are at play here, and that's what we're going to discuss a little bit today. So how is it that we can nurture that space of respect and effectiveness for the cultural practices within our legal system? How do we find that way to open up that space? So this discussion isn't going to be what is Ho'oponopono or kind of a 101. This is more about how do we look forward and find ways to look at that intersection and really make a difference in that healing for those matters that come to court or that are within our community. So I'm going to ask each panelist to start by sharing a little bit about their path in this work, about their journey, and how they define kind of the essence of the cultural practices that we're going to be looking at today. So actually, can I start with you, Laulani?
Okay. Aloha. My name is Laulani Teal, and I'm here. One thing I want to start out with is a correction, because on your program it says Haku Ho'oponopono. However, I want to be really clear that while I do have a lot of practical hands-on experience in processes involving Ho'oponopono and with other cultural practices of conflict resolution, and have done a lot of that work. My primary training is in La'au Lapa'au, which is Hawaiian herbal medicine under Papa Henry Awai, and who also taught his form of Ho'oponopono. And under that teaching, you're not a haku until you're a kupuna of a very specific stature. So I want to be very clear about that, with much respect and aloha, that I am not a haku as of yet. I've still got a few, many gray hairs to go before that. So mahalo. I am, my background in this kind of process is in making pono. It is in it's in working with those things that make right. I've worked with many families. For quite a while, I ran the NHBA NHLC peacemaking project, which worked a lot with families in very severe land disputes and other cultural matters that we encounter a lot. I have a background working with Ohana in cases involving child welfare and a lot of other very difficult situations. I'm also an activist. I'm a frontline activist, and I work a lot with people who do that kind of work, which I do want to say is a very important part of healing process, because we have problems in front of us that are much bigger than can be solved through any kind of resolution. So I do those things, and I'm also a musician. I play music with a long-time music healing practitioner, Liko Martin, who a lot of folks know as someone who brings that healing through music. So in that, and now I run the Ho'oponopono Peace Project, and so we continue to work with families. We work with Ho'oponopono. We work, and and the concepts that are involved there. We work with many cultural practices. We do whatever it takes to bring things together. We work with community issues and many pretty serious situations. So I guess that's about it. Mahalo.
Sean.
So thanks to everyone for having us here. Let me just apologize. I'm totally distracted by how good this thing smells. So my head's not all, this is amazing. I don't know why you don't just wear these all the time everywhere. This is awesome. Anyway, so I think I came to this before I knew I was even on my way coming to this, which is starting out as a kind of angry and violent young man and not having a understanding of why that was the case, but using that as a way to sort of be, as you said, an advocate for both my own people. So I grew up in the Cherokee Nation of Oklahoma, and an advocate for the Black community there as well. And that anger was something that was useful in that context, but it's never something that settled well or felt good to me on the inside. And I was lucky enough to, even though I came from a place where there's not a lot of opportunities, to have a few people who saw things in me and provided outlets for me. And then doing my best to honor
Join the meeting.
Honor the risk that they took by trying to live up to that, and constantly trying to see in me what they saw and not being able to do that. And finally making my way through college, where I was doing tutoring programs for Native students, where I was in New Mexico. I went to college in Santa Fe, New Mexico, to law school, where I saw a real gap in what especially Columbia Law School has to offer in terms of their focus on ways to support Native students to to have a hand in being an advocate for Native issues. And so through that, developed a project to develop a curriculum to craft a way for the ABA to accredit a class that would be available in American law schools. And my professor, I was lucky again. Like I keep getting lucky for people seeing things in me that I don't see. And she really liked it and said, "Why don't we try to turn this into something and see if this will work?" So we piloted it my last semester in law school, and that was very successful. And so she was like, "Hey, you're going to be working in a big firm in New York anyway. Why don't we just turn this into a class that you can teach while you're in private practice?" And so we did that, and that went really well. And then eventually I got, again, lucky again. My whole life is really luck. I don't know what to say. And to be able to come back and teach at the law school. So now I've been teaching mediation and peacemaking, and teaching peacemaking at other law schools as well, and sharing my curriculum with other law professors in the Native community who think it's important to be able to bring a Native perspective on legal issues, a Native perspective on how to use traditional knowledge and traditional wisdom to help come to a better sense of what it means to be in a place where the law affects you. And so, you know, as you all probably know, Native Hawaiians, Americans, are at a weird intersection of their own customs and traditions and laws, and the application of federal and in some lesser extent state laws applying there. Sort of trying to put all that together, and I've been fortunate to have tribes want to reach out in a capacity building effort, and so that's what I've been doing for the last 5 or 6 years, is really helping tribes undergo capacity building measures, court consultations to try to incorporate Native practices, more traditional practices into the court system, and also develop systems that run parallel to the sort of Western style court system that most tribes have, to give better access to not just justice, but access to healing for their own community members, to try to bring us to a place where we were before everything got messed up.
Thank you. Nicklin.
So I've been practicing law in the state of Hawaii since 1974. My father has a law degree. My uncle practiced law. Their father practiced law since the early 1900s. And his uncle, who was his mentor, was a judge on the Second Circuit Court bench. So I think that makes me 4th generation. And when I started practicing, I was with a regular firm, and they didn't know what to do with a woman. I was the only woman. And I remember the judges would say to me, "Next time, tell your boss, send one of the lawyers," because he thought I was the secretary who had come to calendar call. It was right downstairs over here. So I had as my mentor Patrick Yim, because the firm said, "You go and you get whatever court appointed stuff," and that was a whole perspective that I was not anticipating in law school. And the family court was right here on the back of this building, and from there on, I think it was, and it was my dealing with the enormous suffering that was taking place around me and in front of me and before me and after me. And so when I look at my path and why I would be so interested in this subject, I think it also is because of my experience of suffering. And in that regard, I would say that finally in 1993, I came across this great book. It's a Mediation Quarterly Native American Perspectives on Peacemaking. And it just sort of resonated that, hey, you know, we can have a better place for trying out these ways that we've always operated in as a family. I mean, we had a way to get up every day and survive. You don't come down that many generations without survival. And so I still have the book, and I realized then, and I went on a path of finding out and meeting these people, you know, the Navajo peacemakers. I was just enamored with Nanai Kekumu and Richard Paglinawan, Auntie Lynette's late husband was one of the committee members on this, and so we had the resources. And it was just a matter of trying to harness those resources and move forward in our vote, get to the 22nd hundreds. So the 21st century is already underway, and I believe that the term peacemaking is very good in this world that we live in, and the notion of pono, of being in balance, is something that we aspire to and we need to cultivate. It should be the foundation, our pai of the building of our community and everyone in this community. And I think it's significant that it's in this building because of who built the building, our leaders and ali'i, and this is the cornerstone of everything that we aspire to as a people, and what better place to talk about it. I feel like the cornerstone is right. I don't know what corner it's on, but I've always felt it was in that corner. I thank you for being interested in this. I'm still practicing law, and I'm older than all the judges at this point, so who have to bow out at 70. And the issue keeps on coming up. You know, how do we get to this point of a resolution, of a balance? What can you do? You know, and there's no point to fighting to fight. I mean, there's a point to advocate and to push that rock, that big stone that needs to be lifted and moved. But there's no point to fight, and there's every reason for us as lawyers not to settle, but to reach some sort of resolution. I am not a haku. I don't practice mediation. I've been a consumer of mediations for my clients, a consumer of Ho'oponopono, a consumer of arbitration, countless bench trials. And this is a tool that we should be familiar with and using. And I say this for all of us because it's not going to hurt anybody, to have a spiritual component in your interaction with one another. So we'll just leave it at that we can be, you know, thinking about and in the presence of much more than what we would ever have, you know, thought. Thank you.
Thank you. Malia.
Well, hello, everyone. So my first foray into this arena, I would have to say, started from what I would say small kid time, where being from Molokai, born and raised, you know, our island is kind of known as this just say no island when it comes to developers coming in and trying to bring grandiose plans of creating another kind of Waikiki. And I come from, you know, just a background where those who surrounded me, including Uncle Wade Lee, who's here in the audience, was just these staunch defenders and protectors of the Aina. And so I was raised in the Aloha Aina movement. And initially it was, we need lawyers. we need young Hawaiian lawyers to defend the aina and to help us, because it is, only so much huli chicken sales and fun benefit concerts you can put up to pay for legal fees. So that was my initial foray into going to law school and becoming a litigator initially. But I began to realize that not everyone has an equal footing in terms of access to the legal system. And even if you are fortunate to access the legal system, it's not without great personal sacrifice. So I got involved a lot in iwi kupuna issues, native ancestral burials. And I was litigating a case in South Kona on the Big Island. And I watched my client, who was a cultural descendant of several burials that had been destroyed by this multi-million-dollar kind of resort development in South Kona. I watched him being blackballed in his community. I watched his wife leave him and his whole family fall apart. And he was just trying to do the right thing, the pono thing, by his ancestors that had been reduced into tiny fragments, pieces of shrapnel that the dozer had taken out in order to put in a golf course. And I looked at this situation and I'm like, it's like Humpty Dumpty fell off the wall and you're trying to put the pieces together, but you will never make Humpty Dumpty whole again. And I could see that if I continued down this path as a litigator on Native Hawaiian rights issues, dealing with development that is already occurring and burials being destroyed, that I would just become a glorified damage control specialist. And I said, as an attorney, you learn different tools, and I can apply these tools that I've learned to get more at the front end. And so I served on a number of boards and commissions at the state and county level. I was a Burial Council chair for Molokai Island Burial Council. I was the chair of the Molokai Planning Commission. I served on the State Environmental Council. And my whole thing was, how can I change institutions to understand the Kanaka Maoli worldview so that we can reach mutually beneficial results. And then I was exposed to Ho'oponopono through Uncle Wade Lee and my kane, who served under Uncle Wade as a Haku Ho'oponopono and wellness counselor. And I remember I would drop off my kane to work and I'd see angry kids throwing chairs in the beginning of the 21 days. And then at the end of the 21 days, working with Uncle Wade and the Haku Ho'oponopono counselors, I saw families embracing, and I would often see parents coming to my kane and saying, "Thank you so much. My child is a different person. We're whole again." And for me, I was like, I want to understand that, And so through osmosis, I've gotten to learn some of the principles of Ho'oponopono. And one of the things that my kane says that Uncle Wade taught him is you have to work on Ho'opono first. Each side has to Ho'opono themselves. They have to do kind of like a self-inventory. And then when they're able to see their own fault in this, then they're able to come and meet. And so I took that understanding deep within me, and I also saw the impact of Ho'oponopono in my own personal life, because there were certain things happening in my ohana that my kane assisted me with. And I remember just in 5 minutes, he broke me down into just convulsive tears and sobs, and I felt literally like a tree root was in my heart, and it got totally yanked out, and a place that was cold and just stagnant began to fill up with blood and warmth, and I could feel again, and I knew how powerful it was. And so I take those principles and I try to apply it to the work that I do now as a professor of law and Hawaiian studies. I teach Native Hawaiian rights clinic, and we've done a lot of work with different federal and state agencies where there is tension between Native Hawaiian community and these agencies with respect to communities wanting to malama or care for their resources, and government entities not feeling quite comfortable about it or a bit resistant. We've tried to work through some of those tensions, and I have to say we've gotten a lot of positive results.
Thank you. Thank you. As I listen to these paths, I think some of the themes that really come up are about trying to seek out a way to ease that pain and the suffering and the anger. And within the tool chest of the law, not always finding a tool that will help to ease that. So really a searching for a way to find that healing and balance. And often when we talk about this and some of the themes that we heard, we're about family in Ohana, right? We often think about how important, as the family is the foundation of society, that healing within the family is so important. But I'm also hearing the importance of that healing within communities and with other issues. So I'm going to now ask more specifically about kind of the legal kuleana. So when you look at, this intersection between the law and traditional practice, let's first look just for a few minutes on, okay, in terms of Native Hawaiian and Native American legal issues, what is that responsibility of the law? What are the things that the law is trying to protect? What is that kuleana? So I'm going to ask Malia and Sean to just address that, help us think about that part. And then we'll move into, okay, so where does it fall short? So then that'll be the next question after this. So Malia, you want to address that?
So my background is mainly Native Hawaiian rights law, so I'm going to just speak from that level. So, Native Hawaiians have unique rights in Hawaii that you don't see in other parts of the United States. And these are Hawaiian Kingdom laws that have been adopted and persist today in state law, whether it's statutes and constitutional law. And it has to do with a lot of access and gathering rights and religious practices. What I find is that the way in which the courts have interpreted these laws for the most part has been very positive. And what has come out of that is, I would say, the kapa'akai standard, where it's important when, in terms of looking at how a potential project might affect Native Hawaiian rights, there's a kind of a 3-step process where there's an inventory of certain what resources are available and what practices are taking place in a certain area, and then looking at what could be the potential impact of a project on those resources and practices, and then looking at ways to mitigate harm. So I would say there are mechanisms within the law that allow for healing or at least protection of Hawaiian rights. Sometimes, without going too much into the second part of the question, there's sometimes the way that agencies interpret these laws or implement these laws, that's where we fall short.
Thank you. So Sean, this is your academic world. So
That's right.
Share with us a little bit about.
Well, to be totally honest, it's hard to know what the laws are meant to protect. And so when I talk about laws, I mean both the federal laws and then the laws that tribes themselves enact. I'll leave states out of it for the moment. And the reason it's hard to know is because there have been so many different postures that the federal government has taken with regards to the indigenous people in this country that have, I mean, it's a wonder we don't all have actual whiplash from just trying to get our heads around how the federal government has a disposition toward us. So, you go from the termination period where they're trying to completely eliminate us as having any sort of relationship with the federal government to, allotment period where they decide that all of a sudden we need to be, be a part of the country, but using a different set of values. So it's hard to know. So I would say the only thing we know for sure, and this is established in the late 1800s and early Supreme Court jurisprudence, which is that the federal government does have a trust responsibility for the indigenous people in this country. Now, what a trust responsibility means, no one knows, and so there's tons and tons of litigation around that, and it's constantly changing. And it's sort of sad because I would say at least 8, maybe the 9 least knowledgeable people about Native people in this country, Indian people in this country, Hawaiian people in this country are sitting on the Supreme Court. So, and those are the people making the decisions when all this litigation comes down. So it's hard to know what it's meant to protect. I do know that there are certain statutes that have been enacted. So, you have statutes enacted to protect grave sites, statutes enacted to protect sacred sites that aren't necessarily grave sites, but are sacred for other reasons. Statutes enacted to protect different resource rights that tribes may have. It's really difficult to know what it's there to do, and that I do think that's part of why this movement that's starting and has been going for, I guess, since the 80s really, for tribes to, and Native Hawaiians too, to reclaim their own traditional wisdom and knowledge and use that as a force for good and a force for reclamation and restoration and change is important, because it's clear to me that the federal government doesn't know why they're doing what they're doing. And in some cases, I do think they're trying their best. I think the intent is there. And part of the reason we've gotten in such a big mess as we have is because the intent to do, what's that saying, that the road to hell is paved with good intentions, right? The intent to do good has gotten us in a lot more trouble than in some cases than the intent to do harm has. And so since we don't have a sense and they don't have a sense of what their intent is, it might as well come from us. It might as well come from the people who have the traditional wisdom, though we might have to go looking hard to find it again, that have customs that we know have been useful and helpful to us and help us become a culture of people who can unite. Though again, we might have to look hard to find where those are. But it might as well be us who brings this back. It might as well be us who makes the determination for what it will be, how the laws will affect us, what they're meant to protect. It might as well be us to be the people to sort of change where we've been and where we're going.
So Euclid and Leilani, can I ask you to respond to that a little bit in terms of, adding to that, and then also where the pukas, and both Malia and Sean have started on that, but maybe you can add to it.
Well, I thought your question about why do they have these rules if they're not going to enforce them, or what's the reason? We have a National Historic Preservation Act, but do they even have meaningful consultations? There's here, Malia talked about the Kapa'akai analysis that each agency is going to undertake to see if it adversely affects known cultural practices for land, and yet it just becomes, in its actual unfolding, a cut and paste job. of developers and what they present to the table. And here you have this possibility of having a bona fide consultation, and there's no tools, you know, so you have these planners, some who have no training in planning, but they're working for the planning company that's doing the environmental impact statement. And your cultural assessment is part of that statement. And we're all going, wow, you know, and it can perpetuate itself for decades. And I have to say that's where I find things, you know, don't connect, because you have the road of good intentions, and then you have what can be seen as the sabotage of those good intentions. And the question becomes, how do we get some traction here, you know? And so there's a part of me that wants to get to a kind of process, you know, in the consultation process of what the federal government requires. In the Kapa'akai analysis, is it going to have to be the contested case hearing? That's the analysis? That's cynical, you know? That's like saying, yeah, let's get in the ring, and on round 3, whoever's standing up, that's the analysis. It cannot be that way. And so I think we as a people who come from this land and live with our community here, we live here on these islands, and everyone is a member of this community and stands on this ground. And to the extent that you stand on this ground, that is where I think we've got to build. And the Aloha Aina, I'm still trying to comprehend it the way that our ancestors understood it, because I think there's a meaning there that we can, you know, we're still in search for what's going to be that force that comes from the ground up and makes and pulls us together in a functional way. And so I'm still, you know, pondering what types of, because we've tried it all. Mediations, arbitrations, contested case hearings, Ho'oponopono, they can go on for decades. I mean, seriously, and maybe it's all part of peeling the onion. And that's what we're all engaged in, is getting to some point of, you know, of getting to the core. But we all have to survive to be standing around to do that.
Can you help us with this a little bit more? And especially, Laulani, in terms of, you know, how do Indigenous process? And, you know, like what you've been saying, we're trying all these things. We're seeking so much, you know, to alleviate this, the pain and the discord, and to find that balance. So how does this work?
So one thing that I'd like to start with in terms of the concept involved, you know, when we're dealing with law in whatever capacity, you know, law in and of itself deals with positions. Rights are positions, you know. When you work with law in any capacity, you're dealing with the position of one party pretty much versus the position of another party, you know, and that party may be the state, it may be whoever is involved and in whatever context that law exists, so you have those positions. Now, mediation goes deeper than those positions and gets to the interests. And that's where the onus in mediation, in regular mediation, you're looking at the interests of the parties. Ho'oponopono and cultural processes deal with pono. That is where the onus is achieving pono. And it takes that pono, which is within each of us, every single one of us already, and that needs to grow into the pono of the relationship. So, going from positions to interests to that place of pono takes very different kinds of approaches to manifest these things. So that is that's a fundamental thing that needs to be understood before any practical application can go forward in these things. I will also say that we live right now in an extremely exciting and amazing time in human consciousness that is also extremely difficult and challenging. And this is throughout humanity. So, and the way that is manifesting, if we look at the world, right, we're coming from a presumption that it was okay to resolve things by people killing other people. Honestly, that's where we're coming from. And, in a sense, that has sort of evolved into the legal system that we work with now a lot, where you resolve those things in a way where that adversity is placed into a more civil fashion. And now, in terms of human consciousness, not just for Kanaka, but for everyone, we're looking at getting to places where we can actually resolve. And how we get to those places is to look at those practices that have been with us in our cultures all along, because while those things were happening, what was really happening as well in the homes and in the communities, between the fishermen and the farmers, is a great deal of skilled resolution, that comes from the knowledge that kupuna carry, that the elders are able to manifest. And, that is a very, very important thing in terms of how we're going to go forward and apply this. How we're applying it on every level is a return to that sense of pono. And it's not easy. It's very, very difficult. Ho'oponopono, one thing that, I encountered that definitely we've always talked about, the challenge with court, with interfacing between Ho'oponopono and court. One of the many challenges, there's the challenge that it is a family process, really, where you have to cultivate aloha. There has to be aloha, that you're restoring that flow of aloha, so that's a huge challenge. There's also the challenge that of time. Ho'oponopono is not a short thing. It can happen in 5 minutes, as Malia says. There can be like this huge, awesome, thing that just happens, but that's between us and Akua. It doesn't, we can't make that miracle just manifest. It takes the time that healing takes, like any other healing. So that is a really, really important thing to understand. Not to say that it can't be done. It can totally be done. And, we've seen it done. It needs to be done in such a way that respect those things that will, in fact, actually achieve pono, And it's also, in Ho'oponopono, we're dealing with the oya i'o truth. And for those who don't know, oya i'o, it is the deepest level of truth that you're talking about. It's not just what is correct. It's not even just what is factually right. You're dealing with the truth that is deep inside, that in your heart and soul is true, and it's not blocked out by being hidden by any other thing. It's very, very important. One thing I'm gonna have to say, and this is a little bit, partly from the Ho'oponopono world, but more so from the world of activism too, and just working with Hawaiian communities, is that when we're dealing with the court system specifically, there's always an elephant in the room, and that elephant in the room is that the court system can only achieve a certain level of pono. It cannot go beyond that, because the court system itself fundamentally is based upon a system that is, in the eyes of very many people, not legal. To begin with, it's based on an illegal invasion of Iolani Palace in 1893, which resulted in what we have today, through all of the things that happened. And, there's a whole question of, is that legitimate or is that not legitimate? So if the authority comes from that place, it's very difficult to achieve pono. Because of that, it's always going to be the elephant in the room. However, when, many people here talked about intentions, those intentions are very important when those intentions are truly pono. When that is, and when they're connected to the oya i'o truth, because each of us can only do what we can do with what we have. And if what we have is the current resources that are in front of us, whether it's a contested case, or whether it's an Ohana conference, or whatever we may have, whether it's the legislature, we need to do the very best that we can do, and to achieve pono within that, with that whole truth being able to fully come out in that. And that is where the healing will take place, and it can take place.
So I'm gonna go from that elephant in the room a little bit and ask a question that's come from all of us, and it goes to that intersection. So here you are, here's the reality. We've got the legal system, so what do you do? So how do we make that space? What do you do when the case has already been filed? We're trying to restore aloha and there isn't, there isn't a relationship there in the first place. How might we address that place, that intersection place? How might we make a space for this kind of pono or process within the judiciary? So it's a little bit off from where we were headed, but I think it's also getting at that space that we want to. And I'm going to just, whoever wants to jump in, and then hopefully everybody can jump in a little bit with that one.
I guess for me, it's like I said, getting kind of in front of it before it becomes a point of total conflict and hardening of positions, and it's showtime now. So the only way I can really do it is just provide an example. So my Native Hawaiian Rights Clinic, we were helping the Kahana community. They wanted to restore their hukilau traditions and malama, their area as they had done traditionally. But there were jet skis coming in there and breaking up the akule pile, and there was a lot of just neglect of the area, and so many multiple users that the traditions of that place were just being buried by that. And so, our clinic helped the community to look at different possible scenarios on how they could best protect their resources, whether it's through certain kind of marine protection designations. But we had recommended maybe doing a community-based subsistence fishing area, but the community wasn't quite ready for that. So we did this sort of hybrid thing called Kahana Kilokai, and it's sort of like this Makai Watch thing where the community, through small steps, gains, kuleana for their resources and works with the state. But some tensions began to arise from that situation because there were certain, enforcement officers that didn't get the memo that this was a program. And so there was a feeling of like a little bit turf war, kind of. There was some resistance. And so it got a little bit messy in the community, just as there was rebuilding their pride and capacity, and they've been typically looked at by the state as just, kind of like this good for nothing welfare kind area. They don't know how to take care of their place, and they were doing these cultural hours in order to kind of, it was more like a tourist kind of vision for Kahana as a living ahupua'a. But the families were very, I don't know, they felt demoralized by that. So doing this Kahana Kilokai thing was bringing back that community pride. And then these tensions arose. And so the whole program was threatened. And so, I had this conversation with the community. They're like, we wanna sue the state, screw them. And then I said, okay, I come from Molokai Inuia Hina, Molokai, great child of Hina. And on Molokai, we ku'e, but we also have Hina power. It's this kind of very, it's like they call it soft power, but it's actually very powerful. It's like either you're going to ram the door down or you're going to just, or it's like a stone and your water and you just slowly erode it down to a pebble and you just go around it, or you just smooth it over until you and that stone kind of becomes one. So I told them the story of how my great-grandfather, he was a commercial fisherman, and there was one family that stole the fish from his nets. And it was kind of like, again, turf war kind in the fishery. And my grandfather had 12 children, and I think like 6 of them were sons, including my grandfather. And so my great-grandfather, they pulled up the nets, they put the rest of the fish in a cooler that wasn't stolen, and they went to that person's house. And my grandfather thought, oh, we're gonna fight. My grandfather was a teenager at the time, but my great-grandfather said, bring the cooler. And so my grandfather was confused, but he brought the cooler. And so my great-grandfather talked to the old man of that house and said, both of us have big families, and God has blessed my Ohana, and we have plenty to eat. And so I just wanted to share the blessing with you folks. And so my great-grandfather gave that family all the fish, the stolen fish plus what was left. And so my grandfather telling me this story said that it was like transformative, And so I kind of told the Kahana community that. And I said, maybe we gotta look at this, the bigger picture, that this program has brought community pride, and it's worth saving. And so maybe it's about us humbling ourselves and seeing how we can do better. And then if you guys want to do that, then my students and I will make the commitment to work with the state to kind of ease these tensions. And so we planned, they made food. We went to Kahana. You know, my student who was also from Kahana, she was very angry inside, and she said, well, let's just go to the state and go meet them at their office. And I go, no. The land is a witness. The Aina is a witness. And I think that's one of the things too in our court system. Hawaiians fight for the Aina, but it's hard to bring the Aina into the courtroom. And it's hard to, there's so many voices that we have to speak for that cannot speak for themselves. And the Aina is a person. It's not a commodity. It's not an inanimate thing. It's Ohana. So I said, no, Kahana, we have to bring the state to Kahana, and the land has to be a witness. And so basically, without going into too much details, we reached a point of agreement, and there was an acknowledgement that both sides could do better. And then I had this wonderful student from Fiji, and he come from a traditional system with a chiefly system with their fisheries. And so he saw my energy waning, and so he said, so let's kind of all stand in line and let me see if I heard what we agreed to. And if we did, if you agreed, and just take one step towards each other. And we had like 5 different things that we had agreed to, and everybody took steps towards each other, and at the end we all embraced. And then I had another law student who makes ava. So I said, well, let's seal this with ava, that we make this commitment to each other. So we had we had food, and we had ava, and then we was all happy with each other. And I actually saw grown men crying. And I felt open hearts. And then after that, we hew vitamin, jump in the water, and I saw like all the worry lines disappear, and everybody were joyful. And the program is still running strong. So I can see, utilizing some of the principles of Ho'oponopono, we were able to look at those tensions and then disentangle that hihia, the entanglement. And what I did was I made like a tea leaf lei, and then I would tie it in knots. And they said, our objective is to untie each knot in this lei. And we gotta be honest with each other, and honest with ourselves, and so it was very beautiful. And we had, the state, the head of the dole care office, he talked about his childhood growing up, and what he was taught by his father and his kupuna about how you take care of the resources. And that was why he was joined the state, to care for the resources. So we understood that the common ground was we all wanted to malama. We all wanted to care for the resources, but we had to understand each other and see each other as human beings, eyeball to eyeball. So that was successful. And, I'm currently working on a case where 2 Native Hawaiian women were cited for violation of the Marine Mammal Protection Act when they performed the traditional burial rite of a whale at sea. And, under NOAA's administrative law judge, they have to look at it as a strict liability, no mens rea kind of thing, where it doesn't matter what the intent is. But the judge found, the cultural issues and the religious practices authentic and very compelling. And so the administrative law judge cited these women collectively $500, where the fine is really up to $27,000 each, and possible 1 year jail time. But because other Native Hawaiians could end up being held liable under the same act for doing acts of malama. They realize that they have to kind of be the standard bearers, so they're gonna possibly go through the entire court system, you know. So an issue that they're dealing with too is that these whales are, they call it their kinolau, their body forms of the ocean god Kanaloa, and they're seen as ohana, they're seen as family. And so, you know, they were born in a time of po, in the infinite darkness of infinite potential. And these Kanaloa species chanted Kanaka Hawaiians into existence, into the ao. And when they're on this earthly plane, they manifest in the kinolau of these whales and dolphins. And so Po exists in the levalani, in the heavens, as well as in the deep blue sea. So it's important to continue that cycle and return these Kanaloa to Po. So these Hawaiian women, they were actually trying to work cooperatively with NOAA, and they were part of the Marine Mammal Response Team. But what essentially happened was then they were kind of criminalized for performing that bearer right. And so there's issues also, continuing issues of how does NOAA work with Native Hawaiian communities in marine mammal response strandings? And then what happens to their remains if they perform a necropsy? Does it remain indefinitely with the agency? Or because under NAGPRA, under the Native American Graves Protection and Repatriation Act, they could actually be seen as sacred objects. Or they could even be seen as you know, if we're looking at our genealogical connection, they could just be seen as iwi, as ancestral bones. So actually tomorrow I'll be meeting with NOAA, and we're gonna be hammering out what those procedures should be. And it's about kind of this meeting of the minds and hearts and saying, look, we understand your position. We ask that you understand ours. You know, we don't have to be in conflict. So those are the kind of two areas that I'm working on more currently, I guess, yeah.
Thank you. Those are wonderful examples of our role as attorneys, but also as leaders and counselors to shape that kind of dialogue, to shape and teach. And then I love the preventative of how do you help people, which just is so in line with like Rule 11, right? That says we have to seek this. We have to seek that kind of resolution as a part of our job. It's not a shirking of that job. It's a part of our job. Any other thoughts of stories about ways where in this intersection we can make this work?
Can I just say that one of the things that people often need, they need encouragement, they need time, and they need help. You know, I think probably everyone here has a lot of hands-on experience with the level of demand that is out there in the community, you know, that there's such a huge need for assistance, and that the resources are so stretched thin that it's very, very difficult. You know, when you're talking about making good solutions, you know, and this is one thing that I will say from working with Kanaka families, you know, through the peacemaking project that we did. You know, we started it out as a specifically a Ho'oponopono project, you know, giving Auntie Lynette a hard time, you know, about to bring these cases to Ho'oponopono. And a lot of the time, I would say 90-something% of the time, what we found was that before we could even go there, there were situations that needed to be addressed right away, cooperatively addressed within the Ohana, and cultural skills were needed for that. But a lot of times they're very serious to-do items, you know, preventing tax sale of lands where the taxes hadn't been paid, because, you know, when you have Kuleana lands, you have a lot of times 100, 200 heirs that all technically are owners of the place. Some of them have often been approached by developers or other interests and have sold their pieces or whatever. You know, you have these very complicated situations, and you have immediate things that need to be addressed. And the only way that those things can be addressed is cooperatively, but it's not Ho'oponopono that it will take, not the full on, you know, because Ho'oponopono itself is a really serious process. So a lot of times it takes, you know, other just hands-on work, working with the Ohana to be able to bring them to that. In order to do that, there needs to be a lot of support. You know, there's legal resources are needed. You know, we build trusts, we build, you know, agreements between people that will allow them to have the stability to be able to carry on together. You know, and that's cooperative work. It's, yeah, it does involve the legal system, but it also involves the content, the flow of their aloha, you know, and restoring that flow and bringing people together and allowing them to have a good solid basis upon which they can naturally interact as Ohana in the first place. So, you know, those resources, having attorneys, having people to help situations, you know, you have a lot of situations that are so difficult, people just don't even know where to start. You know, right now I'm working with people in Wailua Nui Ahoano, and on Kauai, amongst other places, which, if anybody's been following that situation, oh my goodness, it's a huge difficulty, and there are no legal resources to help people. You know, and when you end up in that situation without help, then people have to do what they can do. Sometimes it's adversarial. Sometimes it's what people think of as, oh, crazy sovereign stuff. You know, it could be a lot of different things, but those are the things that happen when there's not enough kokua, you know. So that is one thing that I would say, just on every level. You know, whether it's advocating, you know, like Malia talked about, you know, helping people, cultural practitioners who really, it should be obvious that they're doing this awesome work and yet they're being persecuted, you know, and that's one of so many situations like that. And, you know, luckily, you know, those wahine who I know well had you know, had Malia to help them. But there are so many who are also there and probably also asking for help, you know, and there's so few resources to be able to make that happen, you know. And in the world of cultural resolution, there are very few resources, and that is the real difficulty. That honestly, there are a lot more resources being used against these practices than to support them. And that's the truth. So, you know, turning that around is where we need to see those doors open up. And I would guess that that's probably true, not only here, that's probably a worldwide situation.
Sean, do you want to add to that?
So it's what, can I just ask, was your question about how do we sort of fit this in after something's been filed,
well, right? That was the springboard for this, but it's kind of the question of, okay, we got and let me just summarize a little bit about what I just heard from Maulani, which is we've got this intersection, right, between the legal system and cultural practices, this yearning for the healing and the restorative practices, but then we also have this need for the legal resources and having those things coordinate somehow. So you have this very intense process, this very deep process of finding that balance, but then we also have timelines, legal timelines, immediate needs. How do you make those, I mean, like, you know, just kind of practical, concrete thinking kind of question. How do those things come together? That's the underneath of that question. Like, for instance, you already have a lawsuit. Now what do you do?
Right. Well, you know, so one of the interesting things is that it's not like the legal process is nimble, and it's not fast. It doesn't occur quickly. And you know, when you think through the time from the inception of a lawsuit until it's done, I mean, I don't know what the average is, but it's got to be a couple of years at least, right? And so if we just said from the beginning, we're going to just begin with this other process, the amount of time that it takes might be roughly equal, in some cases maybe even less, because you're talking about transforming people, and that only addresses the issue at hand. It doesn't address the time savings down the line, because these people have changed themselves in some way. They've become different people by going through the process. They've reconnected with culture, they've reconnected with family, or whatever the case is, that might prevent some sort of conflict down the line. So, you know, I think at business schools, which I've never been to, they teach this concept of like something can be done cheap, fast, or good, and that you can only ever have two of the three. So, right, if something's cheap and good, it won't be fast. If something's good and fast, it won't be cheap, that sort of thing, right? So, and it seems to me that using cultural practices within the existing current legal system will be good, and in many cases cheap, certainly cheaper than going through discovery and all the other, paying a bunch of lawyers, right? So it'll be good and cheap, it just won't be fast. To me, it was like, where's the disadvantage? Because court isn't fast anyway. It's definitely not cheap. And there's not a single study about the outcomes of the legal process or people's satisfaction going through the legal process that says that it's good, right? So if we can have 2 out of 3 using cultural practices and we're batting 0 for 3 using the regular court system anyway, why don't we just do the thing where we can have 2 out of 3? And there are certainly ways to do that, right? There are complications that will come in for sure, because, you know, in best case scenario, you got 2 litigants on either side who have familiarity, have a cultural connection, have familiarity with the processes, right? And then it becomes easier to use that. But another scenario is you have one who has that connection and one who doesn't. And then, you know, in a state like this, or when you're in a forum where you've got a large indigenous population, why not just default to using the indigenous method? Because that's the sort of prevailing, that's where the culture is coming from anyway, that's the prevailing population. The more difficult, and then you have, you know, where neither litigant's connected to the culture, is connected to the process, in which case, you know, I mean, maybe you say, okay, we won't use it in that process. So you maybe say, you know what, we're going to use it anyway. And we're just going to remove the things that would be dishonorable to steal sort of the culture from. But some of the techniques and processes, there's no reason those can't translate. And in fact, if anyone has the time or inclination to check this out, there's a guy in Washtenaw County, Michigan, which is where the University of Michigan is. His name is Jim Connors. And he is doing things I would have said, if you proposed it to me before, would have been impossible. He is using indigenous practices in the state court system there with non-indigenous people in the exact right way, which is he asks us all the time for help. He consults with us. He does his very best to honor us. He asks us for permission to do things before he does anything. And he's getting results that are out of sight. I mean, resolving cases using peacemaking techniques and class action suits in airline crashes. I mean, who would have thought that would ever be possible? And he's told me how he's done it a few times. I still don't get it. It is truly remarkable what he's doing, and what's more remarkable is the way that he's doing. He does it in a way that doesn't dishonor the practices, that doesn't dishonor the people that the practices come from, and he does it in a way where he's clear with us along the way about how we can be of help to him and how we can help guide him to do it the best way possible. So I guess all that is to say, we know it can be done when you have two people who are connected to the culture. We know it can be done where you have one person who's connected to the culture and one who isn't, especially in a place like this where even if you're not a native Hawaiian, there's something about being here that you sort of you become part of, you become familiar with the culture in a way that you could understand the process, even if it's not your own. And now Tim is showing us it can be done with two folks who have zero connection to the process, who have zero connection to one another, except that their daughter or son happened to have bought an airline ticket at some point and flown on that particular airline. That's their sole connection to one another. And he's making these processes useful and for better outcomes for the people. So we know it can be done. So the trick is, or the question is, are we going to take the time to do it? The real question is, do you want better outcomes for your people, whoever your people are, right? If you're talking about the people going through the state court system who may have cultural connection or not, or you're talking about if you're a tribe or a native people like the native Hawaiian, where your people are your people, do you want better outcomes for them or not? If the answer to that is no, what are we doing here in the first place? And if the answer to that is yes, why aren't we doing this? Why aren't we pursuing this other method?
I think we're at the point where we should start.
Aloha, everyone. I was expecting a transition. Hi, I'm Laurie Tochiki, and I'm gonna moderate our panel discussion. And you know, we're like Brady Bunch squares right now, and so as you're watching and playing with your settings, this might be a time for speaker view. It might be helpful just because our panelists are popped up among the Brady Bunch squares. But thank you so much. I don't know about all of you, but as I watched that, I was struck by a couple of thoughts. One is, it seems like so long ago, and yet it seems like only yesterday, in March 2018. So much has happened, and who would have thought that we would be in a pandemic when we watch it again? And I was struck too by something that Laulani, said about how important this was for the healing and how we need that healing more than ever. And I think that seems almost prescient, don't you? When we think about where we are right now. So I'm going to ask our panelists who are here, and we're so grateful that they're here joining us again. And Sean, I'm sorry that we're not giving you a lei, because one of the best parts of that video was watching how much you enjoyed the fragrance of the lei. But I'm going to start off by asking each panelist to share a reflection or maybe an update, now that we're here 2.5 years later. And then just to queue up questions, the next question after that, I'm going to address one that came into the chat, which are barriers and obstacles or challenges to utilizing Indigenous conflict resolution methods. And then along with that came a thought about technology, and how might technology play into utilizing Indigenous processes in the legal system or in conflict. So I'm going to, if you don't mind, I'm actually going to call on Malia first for the reflection and updates, and then I'll go to the other panelists. So Malia?
I would just say that I would echo what you said, Laurie, about that it's prescient. Now more than ever, these things are really important. And it has been a really long time, but I realize that the issue is still relevant you know. So it was nice to kind of go back to that time and then see how I have shifted and changed. So, you know, I'm Euclid and we are now part of the this cohort that is being trained by Auntie Lynette Paglinawan in Ho'oponopono. And, you know, we grapple all this time, like, how can we integrate this into the legal system? And we have now a greater understanding, you know, that Ho'oponopono is about family dispute resolution, and it is incredibly difficult to see how we can actually integrate this into the legal system. But, you know, I think if the parties are willing, and if they're willing to go on a really deep level, like for Auntie, she talks about Oya I'o. You know, a lot of Oya I'o is the absolute truth. And as attorneys, we don't necessarily go for absolute truth. We take our sides, you know, it's an adversarial setting. But if there can be certain ground rules that are set, and there is a true commitment to that Oya I'o, then I think it's possible. And we know that our legal system is broken, and so we really have to try and commit ourselves to making it work. So I think, you know, traditional peacemaking and principles of Ho'oponopono are, you know, absolutely necessary.
Thank you, Malia. Thank you. I'm going to ask Laulani next because, you know, like just linking into one thing that she said in the presentation about capacity, you know, and so what you just shared talks about capacity. Laulani, where I don't see where you are, but wherever you are, could you share, please? Thanks, Laulani.
Yeah, you know, I think that it's really, really important to understand that part, because as Malia said, you know, the legal system is not necessarily going for Oya I'o truth. And in fact, I will say that it's extremely difficult to achieve Oya I'o truth, specifically when you're in any legal matter, because achieving that level of truth means that that level of truth is determined internally, you know, and in a relationship with that which is pono. And that fundamentally means that if you express something that is contrary to the position that you're trying to push, it may be used against you in the way that the legal structure is set up. And so therefore, people don't have the level of safety that they need in order to resolve on a deeply cultural level. And I want that to be understood, because you know, in framing what people need, a lot of it is about achieving that level of safety. You know, I think on the panel, I frequently encounter that in families. They're trying to save their land, the taxes are unpaid, but there's all kinds of conflict over, you know, who's going to pay the taxes, and just basic things like that that can end up, everyone can lose, you know. And that same kind of thing happens in many different scenarios. So creating the sense of space where there's a safety, making people safe enough to feel that they can achieve pono, that they can feel that aloha can flow. You know, those, it seems very basic, but it's very, very challenging. So in terms of those resources that are needed, a lot of times, you know, you need people who are good enough at working, you know, things maybe within government so that they don't have that tax burden, maybe, for example, or who can assist with, getting the legal system to stop, so that the family can have that safe space to resolve that conflict. Because often people actually do have the resources inside of their families, but they can't utilize them because there's not enough safety.
Yeah.
And so looking at that, there are many kinds of professions, whether they be social work, government, government work, lawyers, all kinds of people can play a role in making that better, and as opposed to making it worse. Unfortunately, we have to be very real about the fact that there is a lot of pressure to make things worse. Very honestly, there's a lot of pressure for Hawaiians to lose their land because there are developers who want it. There's a lot of pressure for people not to, rise up and, do whatever it may be, restore the sovereignty of Hawaii or whatever the case may be. There's a lot of pressure for those things not to happen, for a place like Mauna Kea to be protected, for example. And because of that, there's very little safety in any situation, even in a household, small microcosm of conflict, and I think that it's very important to understand how those things affect each other. But all kinds of resources can also help those things. I don't know if that answered the question.
It does, and it actually starts to go into the next question too, so thank you. And that safety, I just want to reflect a little bit that maybe today versus 2018, we feel less safe. And just because of our context and everything that's going on around us. So even more so, this is important. I'm going to ask Euclid to go next to share. Euclid? You have to unmute, Euclid.
I'm in my horrible office. Well, one thing I would say is that we're just smashed at work, and at least in the area that I practice in, which is in the probate court, and there's a partition court having to do with the co-owning by families. We have this Heirs Property Act that went into effect. I think it's hard because we can't we can't go to the courthouse. So everything's done remotely. And we did have, in one of the courts here in Honolulu, Judge Crabtree, he took the time to bring tea leaf and some of the accoutrements of the world we live in into his courthouse. And I had a partition case going on that had been going on since 2013, and we managed to come to a resolution between the family and moving forward. And I, in many respects, acknowledge the fact that we were assisted by having the tea leaf and the other things in that courthouse at that time with that judge who had intentionality about it. So when we get, like I did this morning, a case finally where the woman had been financially abused, and she finally passed away this week. And so this judge is just beside himself with too much work. And he's trying to be have some empathy for this death that just took place and how it terminates jurisdiction and things like that. So his court now has lost jurisdiction because of the death of the ward. And we weren't able to be in the presence of one another. We were all on this. It's not even with Zoom. It's a WebEx thing, so it's just audio at this point. Every once in a while, he'll make us do it on the computer if it's a very contested hearing where we at least have to be seeing each other's faces. And I have had, which I didn't like it, where, you know, I had to go down to court because he made us, and then one of the attorneys just became crazed and they had to remove him. And so you're in that courthouse going, what am I doing here? You know, why do I have to be here in the presence of a colleague who won't wear his mask, is going amok, and 3 sheriffs have to come in and haul him out of there? So I think a setting is so important, and that's what's not happening often enough, that we cannot be in the presence of one another and we cannot reinforce our value and the value of trying to resolve disputes. Mm-hmm. And so it makes it harder. It really does. And I'm trying to like figure that out, because I don't see an end to this. You know, I mean, this judge is, you know, continued us till I'm in February on some of these cases. It's horrible. And I don't know if it's going to be over, you know, so that we can at least attempt, you know, a status conference or a settlement conference where their parties are not on some kind of remote control, like, or remote, you know, distance scenario. So that's we're losing the power of our environment over that, which is a support, is a complete support.
And one of the comments that came up, Euclid, while you were chatting, while we were speaking just now, is about trauma and how we need to be wise about how trauma is affecting us. And it seems to me that what some of the things that we were talking about 2.5 years ago about healing is also about how we deal with trauma, but how do we overcome the obstacles of bringing in Indigenous practices now in this world. So I'm going to ask Sean to speak now, and you started to respond about the obstacles and a little bit about technology too. So maybe if you could weave in your reflection and move into that piece, I think that would be really helpful, Sean. And welcome, and I'm sorry no late today.
Oh man, I was watching again. I had forgotten how overwhelmed I was with that. I'm surprised I could pay attention to the rest of the panel. It just brought back such good sense memories, which at the moment are so needed. You know, everything everyone is saying about safety and trauma is all so relevant. One of the things I find, you know, I'm trying to look for the silver lining through this pandemic. And one of the things that I find is that this may be the first time where there is a collective trauma, not only as a culture, as Indigenous people, but as a culture of the United States, but even the globe, where we can finally acknowledge that we've all experienced this. You know, for the US, I think the closest we get in recent memory is 9/11. But I mean, the truth is, very few people actually experience that trauma. We saw it on TV for sure, but in terms of experiencing it, That's about as collective as we've been willing to admit, because so far we're not willing to face the collective trauma of slavery or genocide here. So this may actually do us some good in the end in helping us come to some understanding of a collective trauma that we have gone through and what trauma can do. I have found myself amazed at how poor I am at focusing, and not something I would have ever thought of myself, but completely distracted, and inability to create coherent writing, thoughts. I've been a much worse parent. I've probably been a closer parent, meaning that there's been lots more hugs and kisses and so forth, but my temper is shorter. My ability to withstand, the millionth question or whatever, it's all shorter. And so I hope that what we have started to do is come to some better collective understanding of our own limitations and weaknesses, and help integrate that as something that will engender empathy for others. I've certainly been a much softer teacher this semester as I came to understand how difficult it was for me, who to be totally frank, has gotten to go through this pandemic very comfortably. Both my wife and I have stable jobs. The schools we work for continue to pay us. We have a good internet connection, so we can work from home when necessary. Child is healthy, we're healthy, none of us have gotten it. We've lost a couple of people to it, but certainly not like some others. And to have students be going through what they're going through, I've softened. So all that was to say, I hope that we are thinking about safety and trauma as we're going through these things, and maybe we'll be more willing to interweave trauma-informed care, trauma-informed practices as we go through these. And hopefully it will be some incentive for some of us, I especially need to learn it, to be trained in that so that I can be better at it as I do any of the things I do. So to go back to the question about some of the challenges, it's hard to identify the challenges for any specific community of people, because what is a challenge for Native Hawaiians is different from what's a challenge for Cherokee, and what's a challenge for Cherokee is different than what is a challenge for the Prairie Band Potawatomi, which is a tribe I have started to be a judge for, a district court judge for, and have been running their Healing to Wellness court. And the challenges there are just different than you experience. So I'll say, but I imagine what's common for all of us, no matter how different our specific practices might be, is the logistics that come with, this is even without COVID, so even without us going through a global pandemic, the logistical challenges that come with having a space for people to gather, actually physically getting the people to be able to gather. There are lots of challenges that come with the fact that what we're trying to do is significantly more noble and significantly more complicated than what the legal system is trying to do. They're trying to solve a problem basically as quickly and cheaply as they can. Turns out it's not very fast and it's not very cheap, but that's what we're trying to do. We're trying to solve a discrete problem. What Indigenous communities are trying to do, what Native Hawaiians are trying to do, is to integrate the idea of healing across a community, not just the individuals who are in conflict, but the community as a whole. And that takes tons and tons of time and effort. Resources aside, just the time and effort involved is so much different. And I would have before said, maybe technology can actually be an aid in that. But now I wonder if the technology isn't just reinforcing and re-traumatizing us as we go through it. As I'm sitting here, you mentioned the lay, and I'm thinking to myself, I said, I actually had a moot court team competing today, and I said, ladies, if you end up advancing, I'm not going to be able to be there with you because I'm going to be in Hawaii. And they got super jealous. They were like, really, you're going to Hawaii? I was like, no, I've got to watch Hawaii through a computer screen. And it sounds ridiculous, and I certainly am making a joke of it, but it is traumatic to have to be doing this with you all instead of being there, being in person and smelling the lay and feeling the texture in the air as you all talk, and feeling the air in the room contract and expand as you say things that are meaningful. And so I don't know how I feel about technology in this space. And it certainly is better for us to be able to communicate than to not be able to communicate. but as something we want to interweave as a normal part of the practice, absent a global pandemic, of course. I'm not sure if that's something that we should be doing. You know, before I might have said differently. I honestly probably would have said differently, but you know, the experience of going through this has probably changed that for me.
Thank you. Yeah, but in so many ways, it's also taking us back to the importance of, and as I'm reading the comments, you know, when we talk about respect, aloha, caring, humility, all of those things. And I want to reflect for a second on, so Ohana conferencing pivoted to 100% virtual in March. And you know, when family members have been broken from one another, and we're calling them together because there's a big problem in the family, sometimes they haven't spoken with one another for years. And what they need more than anything is to be together and hug. I mean, I honestly, and the fact that there isn't that physical safety in order to connect. And yes, we can connect on these little Brady Bunch squares, but the need, and I had to smile when Euclid said, you know, this person who's not even wearing a mask, and so safety and connection and all those things that are there. I think, so these are barriers right now, but I also want to ask Malia and Laulani to circle back a little bit, because I think, you know, what are the barriers? And we're using the word integration, and somebody pointed out that, you know, is it really integration, or is it maybe wholehearted acceptance, or maybe it's not necessarily alternative, but maybe it's the way. You know, what are some of the challenges and opportunities? So Malia or Laulani, if one of you wants to take that. It's a big question, so you can go with it any direction you want to go.
I think as I'm learning more about Ho'oponopono from Auntie Lynette, I think it might be important to kind of state like what the ground rules are in Ho'oponopono, and then from there determine whether that's too hard, you know, or if it's valuable at all in a legal setting. So what I've learned from Auntie is that, one, there has to be kind of an agreement, a mutual agreement that each person involved is committed to resolving the issue, that's more important than their self-interest, that they really want to be whole in that really whole sense, not in the kind of lawyerly sense, you know. And then there has to be sort of like a reflection, internal reflection on your part, you know, and there sometimes what the haku will do is interview each person individually to get a sense of what the issue is, and then provides that safe space. So if things get a bit really emotional, you direct your feelings, you know, about the situation to the haku or the facilitator, and the facilitator kind of, you know, you have to go really deep to the issue, and that's where the oya i'o is. Like, you have to look at not just what's said, but what's not said. You got to look at body language. You got to be able to kind of like really ferret the truth behind the words and behind the body language to bring about that healing. So, and then there's this process of mihi, you know, like confession, where you really confess your own part in it, and you seek forgiveness. And then if there's like someone that's still kind of in resistance, you concentrate your pule, you know, your prayers to help that person to ho'opuka, you know, to kind of overcome and move through that pain. And then you kala, you know, you release it, and then you oki, you cut it, you know, and you don't bring it back up again, you know, and there's different layers. So sometimes you have to determine you know, it might not be a big group. It might be a smaller group, and you address. It's like an onion, Auntie explains. So like you gotta address the different layers until you get to the root of things. So it'll take several sessions, you know. So it really requires that dedication and you know, being grounded in the truth and having that aloha, you know. And so Auntie kind of explained to us, you know, it's difficult as attorneys being zealous advocates, you know, and adversarial posture, and you don't want your client to lose ground or give up ground. So those things kind of run counter to each other, you know. And she said that, you know, the way that she was taught by Tutu Mary Kawena Pukui, she said Ho'oponopono is for families. And it doesn't work in other settings necessarily, or Auntie was very, you know, doubtful that it could work because she said people have different values. And in a family, you're committed to making the family whole. But in a adversary, you know, when you got different parties with different cultural values, they might not be on the same page. So you really have to, in order for it to succeed, I think you really have to give them that. I mean, you really have to prepare them to be in that space, to really want that, and to it requires humility too. You have to humble yourself and admit you did wrong, admit your part, you know. So if people are not like ready to go that deep, then it's not gonna work. So
Thank you. So much of what you're saying is, it's kind of like, you know, maybe that's the problem with this whole the whole idea or concept of integration versus, you know, maybe it really is that that the legal system's like the iceberg, the tip, and then underneath is all the stuff that Ho'oponopono can actually address.
I wanted to say one more thing, Laurie, I forgot to mention. So, you know, in that talk 2 years ago, I was talking about NOAA, the federal agency, and then our Kia Ikana Law Network. You know, we were actually making good headway after that and reaching some agreement. But there was always this kind of sense that Western science is more valid and important than Native Hawaiian traditional ways of knowing. So there are, again, that the values and the this sort of power imbalances were in there. So they encouraged us to deal with the low-hanging fruit and that we would continue to negotiate. But there was an instance where these whales were euthanized and the cultural practitioners were not really allowed to help them to recover and float them in the water. They just euthanized them, you know, made an executive decision. And then they utilized the Hawaiian presence as saying that they collaborated with cultural practitioners and they were on the scene. So they used us to window dress themselves. And I came to the point where I said, screw you guys. You're not about Oya I'o. You're not being truthful, and you're not respecting us, you know. And so I cut off the relationship with them. And so they ended up hiring this, it's called CP, so this woman that resolves wildlife conflicts around the world. And she said, you know, NOAA is really wanting to resolve this. And what I did was I punished them. I said, I will cut you off. And then you will feel what that means. Because we've been acting in good faith. And you know, you just ran wild with it, and you disrespected us. So we're going to remove our aloha from you, and we're not going to work with you. And we had made partnerships with state entities as well, and they also cut NOAA off. And so then they were like, oh, so then now the power shifted, and then they want to work together, but they're more apt to listen to a white woman than to listen to us and our methodology. So we're actually using her as a way to bring a peaceful resolution. But I think there is something to say about those power imbalances and the disconnect between between different cultures. Yeah, that has to be overcome.
Thank you, Malia. That's a powerful story, and it does lift up this question, which is one of the questions, which is, what do you do when the values and the culture of the systems don't match up? Laulani, Euclid, Sean, did you want to weigh in on that particular thread of discussion?
Can I speak to that a little bit?
Yes, please.
So, I think that what Malia describes is something we see in almost every front. We see it in every land struggle. We see it in family resolution. I definitely, at one time I worked for Epic Ohana conferencing. I definitely saw it there. We see it practically everywhere that, the indigenous practice is, there's kind of an understanding that practice is important, but when it comes to the actual thing, when it's actually in practice on the ground, a lot of times it doesn't fit very well with the existing power structures that are bigger than that, whatever that resource is. So if you have, say you have a legal program that's doing good restorative justice, for example, that program exists within the context of a much larger system that likes the flavor of indigenous practices, but it doesn't want to encourage their actual full development, because removal of that given situation from the legal system, for example, means that there would potentially be, potentially not be control over some interest that the legal system has. We see that in the Mauna Kea situation is one that a lot of people are familiar with, and there's been a lot of there's been a lot of conflict resolution that that I've been involved with, that many others have been involved with. We've spoken directly with the governor, with many others, with TMT. We all pretty much know the TMT board members personally at this point, and all these things. But at the same time, fundamentally, not building that particular telescope, right? Resolving the conflict. Resolving the conflict, when you actually look at it from an indigenous perspective, resolving that conflict means not building the telescope, and in other cases, resolving the conflict means not doing whatever that harm is. And the problem is that even if the people who are the decision makers and those who are involved in the conflict resolution don't want to do that harm, there are strong interests that do want that to continue, because there could be, because, not building that telescope means that any, for them, in their minds, means that any large development project could potentially be stopped by a whole bunch of indigenous people coming and sitting in the road, a bunch of indigenous kupuna who just say, absolutely not, we're not doing it that way anymore, we're doing it this way, and honestly, there is a lot of interest in that power not shifting in that way. And that is a lot of the reason why you see things being difficult. I noticed, I want to acknowledge Paul in the comments, who has, who's put out some very good points about how, perhaps some of these things should be alternatives to the court system as opposed to being in the court system. And that's absolutely correct. They almost can't happen inside of court, although we do need support from within those systems in order to make those things happen. Because to even take it out of the court system, you have to have support within the court system to say, okay, we're going to just pause this whole thing and allow for this healing process to take place in the time frame that it requires, which, as you know, was said many times, is not necessarily short. We're talking about Indigenous time frame, not a court calendar, you know. And so, you know, if we want to move from window dressing, as Malia very aptly put it, to something that is actually Indigenous appropriate and something that can work for many people, you know, and actually be effective, then what we need to do is we need to take this whole thing out with whatever resources we have inside the system, outside of the system, and, you know, and create those alternatives that also interface with the system in a way that is functional and helps people, so that when that goes then back to, you know, if you take it outside of the system and you work out a solution that does work, that you can take that back into the system and resolve the problems that are created that interface with that system, whether it's criminal justice or, you know, child welfare or land issues or whatever those things may be. You know, they need to work both outside and inside. And so all aspects are needed in that, in creating that alternative that does function within an actual Indigenous context, even if it involves people who are not necessarily from that Indigenous context.
Yeah. Thank you so much, Laulani. That is just really a provocative, yeah, I don't know, I'm almost speechless, but I'm a Portuguese, so that doesn't happen often. But Euclid, I saw your mic was unmuted, so I want to ask you to weigh in on this, because this is a really important conversation.
I think the some of it is time. I mean, not everything is capable of I don't want to say a quick fix, but it's in piece, you know, it's step by step, piece by piece. You don't always control events as they occur. You know, there's death, there's new life, there's, you know, the horrible flood, there's the fire that burn, you know, there's so many events that can transform the conflict in a way, or, you know, change it or reframe it. So I have recently started using again that Kale Nu'uhiwa's, you know, tracking the moon and the tides. So the lunar and tidal, because we live here, you know, my office where I'm sitting right now is 5 blocks from the ocean, and my house is we can't escape where, you know, nor do we wish to, but we are here, you know, with the dead mo'o killed by Hi'iaka as she ran to, you know, away from her sister Pele to Kauai, are the small islands in the ocean outside my door, you know, outside where I live and have lived since I was 5 years old. So it's a huge canvas, and it's I think, you know, what it is I miss the contact with the other parties, because that's so important, because we're dealing with human beings you know, I mean, that's how I look at it. I need to have more of a tactile engagement, even with a judge. You know, some of these guys, I've known him for 30 years. I want to see how he's doing now that he's the chief of the First Circuit Court civil. You know, I mean, is he crushed, short-tempered, grumpy, sick, you know, all of this stuff? You hate to see him drop dead on you, you know what I'm saying? Because some of them get sick and that's the end of it. So lawyers get sick and drop dead in the middle. You know, we had one of them in the right following the end of the contested case hearings, one of them dropped dead while swimming in the ocean. That was representing the University of Hawaii. You know, and I felt his absence because I've known him all these years, and yet he was on the other side, you know, and so that's what I am having to come to grips with. How can I approximate proximity today? Because we still have all this stuff going on. Yeah. It doesn't stop. And I'm lucky because I've chosen to primarily be engaged by people who are Native Hawaiian. So my clientele is, because I'm in private practice, it's, you know, because then I've got some skin in the game as to how I talk myself into it. I got skin in this game because these are my people and I'm honored to be here and to serve. But you want to have a game. And it's really hard without the proximity. And so how do we do that as a next step? Yeah. Because I'm over 40 years into this game. I've been practicing law since '74. I don't know how many more years I've got, you know, to be engaged like this. And maybe that's the nature of it. You come, you go, it, you know, it just keeps going.
Well, thank you, Euclid. I think what we're really talking about is that connection that we have with one another and how we're connected to not only each other, but to our ancestors and those that came before us and the land and all, you know, I think that's the real heart of what we're talking about here. We have about enough time for maybe one more round, but Sean, I wanted to make sure I touched base with you because in this round of the questions, and we've I'm not sure if there's a thread that you want to pick up on right now, but I did want to touch bases with you.
Yeah, so you know, when Leilani was talking, she said the phrase, you know, she's talking about getting through solutions, and she said the phrase indigenous time, which I loved, because what she meant was we're talking about time spread out over time, possibly even past our lifetime. I chuckled a little bit because in the continental US, when we say Indian time, what we mean is the person's always late. But that concept is actually built into that, which is time means something spread out. And so when we talk about the idea of what happens when our values are at odds with the kind of prevailing legal system, one of the things that I got lucky enough to be just totally floored by was I was in Tokyo doing some training with some of the ambassadors there who had been talking about the idea that they don't actually know how to have diplomatic conversations when they get the job. They get appointed and they've never had any training, and they feel like they spend years training on the job and making mistakes, and they wanted some training beforehand. So it was an interesting kind of humble thing for these very accomplished people to come and say, this is like what we need to be better. When I was there, one of the ambassadors was engaging me pretty deeply about what I do in the indigenous peoples front. And it hit me all of a sudden that he was asking, do you think it's going to work and whatever else? And it hit me all of a sudden is that I actually don't think it's going to work. I think most of what we're doing is fighting a hopeless battle, and the dominant culture's attempt to basically eradicate us as a culture has probably worked pretty well so far, and it will continue to work. And like embracing that hopelessness actually made me feel a lot better about what to do and why to do it, which is to say, you do the right thing for your people because it's the right thing to do. There's not an eye towards winning. I'm just going to keep doing it. I don't know if you guys have ever seen the film Saving Private Ryan, but at the very end, the Tom Hanks character, who's the sort of general, or who's leading this platoon of these men, he's getting his men out, and he's wounded, and all he has is this little 45, and there are these 3 tanks coming at him, and he starts to shoot at the tank with the 45. That is to say, there's no way that 45 was going to do anything to those tanks, but it was worth making the effort anyway. And then I started thinking about when it was in Japan where I was doing this, and I started thinking about a talk that the former Secretary of Defense, I forgot what they call it in Japan, but for us it would be the Secretary of Defense, was having a conversation, was talking to us about a decision that he had made some years. He was a former, so he hadn't been the Secretary of Defense for a long time. And he was talking about a decision that he had made that basically got him fired. And he made what was a very controversial decision. And when they asked him about why he made that decision, because they thought it was the wrong decision, he said, "We're Japanese. In 1,000 years, we'll see." And I loved that approach to doing what you feel is the right thing, which is to say, we aren't here for all of the hard work that we're doing now to pay off for us. We're here for all the hard work that we're doing now to pay off for future generations. I don't know about if Native Hawaiians have this sort of cultural value, but for most tribes in the kind of plains and in the Southeast, we have this value of saying we're supposed to protect 7 generations. And those are obviously, well past our lifetimes. And the more I can think about that, the more I can deal with, I don't have a solution to what to do when our values and the values of the prevailing legal system aren't the same, except to say what I do know to do is to continue to have the conversation, continue to work, and embrace the hopelessness. That is to say, the more that I don't think it's going to be effective, the easier it is to just do the work anyway. I'm not waiting for a solution to pay off in the short term. I think it's never going to work, and so I'm just going to keep working as hard as I can at it. And if it pays off well past my lifetime, if it pays off for the 7th generation beyond me, then great. And if it doesn't, then that's okay. But like the Minister of Defense said in Japan, in 1,000 years, we'll see.
Thank you, Sean. I think there is that connection. I would ask Malia Lalani to respond to what Sean said, because that's really important. Is it window dressing? Do we just say, look, here it is, and we will preserve and we will foster and we will strengthen? So Malia, yeah.
I think, yeah, definitely we have very similar values and the way that we make decisions. I just remember talking to a friend of mine, and so we were talking about the prophecy that was made at Paku'iheau in 1819, shortly after the ending of our kapu system and just before the arrival of the missionaries that converted a lot of us into Christians. This prophecy was made on Molokai, where I'm from, and the kahuna were foretelling what would happen to our people over the next 200 years, that the ali'i, the highborn, would fall, and there would be much suffering of our people. But sort of at that 11th hour, we would rise again, and it would be the common people of the land. And there's a saying, Ho'ale kalepopopolo. The people, you know, who have all that lepo or that soil on their legs as they're rising out of the taro patch, they were the ones that would be restoring the culture and restoring that air, that sovereignty. And then in 2019, 200 years later, Mauna Kea happened, you know, and then we're seeing COVID and this, we're talking about this hulihia, this turning, this transforming that's occurring, and it's throughout the world. Indigenous ways are being looked at more with respect, and you know, whether it's dealing with climate change, COVID, is like, how do you survive these things? You know, we have to shift, we have to change. So when I was talking to my friend about that we're now in that hulihia, we were remarking that, you know, many of our ancestors died from epidemics, and it's awakening this kind of feeling in us, you know, but also this realization that we are the strong, that we are the resilient ones, we're the ones that have survived this. And it was, you know, that sense of what the kahuna, what the ancient priests were foreseeing and foretelling. It was really about let our descendants survive, so that they can be here at that hulihia, at that turning. And so, you know, I deal a lot with issues like protection of ancestral burials, and we're looking at, you know, a missionary family, you know, 150 years has managed to totally oppress the people and adverse possess their lands, to the point that there's only 5% land left in this remnant Ahupua'a traditional land division in Hakipu'u. And so I'm helping these remnant families defend their ancestral burials, their sacred sites and their lands. And they're, you know, traditionally they're taro farmers, they're mahi'ai, they are the lepopopolo that are rising. And so I really feel that you know, the mindset of our kupuna, of our ancestors, was that we must live, and that we must carry on these precepts, and it has to live in us until it's ready to bear fruit, you know. So the sense that I get is like we are like seeds that have been dormant for a while, and with this heavy seed coating and all this generational trauma that we've experienced, and colonization and all this kind of stuff, these are the scarifying of that seed coat. It's scratching that seed coat, and if we continue to remain in trauma, we're losing the point. The point is that it's time to let our seed coat go, and let that pula, let the sprouts begin to emerge, because it's time for us to bring this knowledge forward, and it's time for us to help the rest of the world to survive and make that transformation in this period.
Malia, I cannot think of a better way to close our discussion today than what you just shared with us. I know that, and certainly if we were at the Supreme Court again, we would share some food and we would be able to talk. And I bet that there's a lot going through so many, as I see your faces, so many thoughts that would be such a rich and amazing conversation. But it is 2:30, and I am going to close us for today, and just express my thanks to Malia and Laulani and Euclid and Sean for joining us, and for all of you who are here in this really important conversation. I am just so grateful and I'm so grateful to the center and for the all of the organizations that took the time to put this conversation together. So thank you, everybody.